We're about to begin two shorter panels on arbitration. Let me introduce the first one, which will go till about 20 after 3. We talk about the law of unintended consequences, but maybe there should be a law of predictable consequences. The Supreme Court has supported both arbitration clauses and clauses that waive the right to bring class action cases, and workers' lawyers said okay, with the result that lawyers are now filing dozens or hundreds of similar arbitration claims. How are these claims to be handled in arbitration? By lawyers on both sides and by the arbitrator. Carrie Engelman is with us. She litigates individual and class cases, including both wage and hour and ERISA at Morgan Lewis in Boston. It's her first time with us, and Carrie will give you a big New York welcome.
Welcome, Carrie.
We welcome back Joe Sellers, a longtime leader of the Plaintiff Civil Rights Bar at Cohen-Milstein in Washington, a member of our advisory board of our center, and one of the really distinctive plaintiffs' lawyers of our generation. Our moderator, Steve Sonnenberg, who had a 15-year career as a psychotherapist before attending law school, then a distinguished career as a lawyer representing management, and now presumably uses all of those skills as a mediator and arbitrator on the JAMS employment panels, and I turn it over to Steve.
Thanks very much. We're all delighted to be here. We're going to jump right into mass arbitrations. What prompts counsel for plaintiffs, for claimants, to pursue mass arbitrations? Are there reasons other than class waivers in arbitration agreements? Joe?
Thank you. Good to be here with everyone. And before I answer that question, I want to respond to a point that was discussed at the prior panel for a moment about what plaintiffs' lawyers think about arbitration. I can't speak for every plaintiff's lawyer, but I will speak for those I know in saying that I think arbitration can have real value in certain settings where there are comparable negotiating, bargaining positions, and where the opportunity to elect to proceed with arbitration comes up when the dispute arises rather than committing to agreeing to pursue arbitration before you even know what the issue is. So I just want to be clear that there are a number of us who are fans of arbitration when in appropriate settings. So to answer the question, for the most part, I would say we pursue claims of mass arbitration when we cannot pursue them collectively in some kind of class or collective action. Indeed, I think one of the problems with mass arbitration is the transaction costs are enormous. You end up litigating a lot of claims individually that you could litigate collectively at one time. And so you lose some of the economies associated with that are achieved by class actions. And indeed, when we look to see what kind of claims we would pursue on a mass arbitration basis, we often look for features of those claims that would make them susceptible to class certification. Are there common policies at issue? Are there things about the liability that we could establish with evidence that would be generally applicable throughout the particular arbitral claims? So yes, I think we generally reluctantly pursue them because we can't pursue them collectively.
All right. Well, we all know, we've heard a lot about class action waivers. Carrie, have mass arbitrations changed employers' assessment of the value of class action waivers or even of mandatory arbitration agreements?
I think it depends a little bit on the employer and the company, of course, but from my perspective, overall, companies are still seeing the value in class action waivers and are still wanting to incorporate them into their agreements. I think the change that we're seeing from a defense perspective is on the front end counseling clients on the risk of mass arbitrations, because some companies just aren't aware that this, relatively speaking, this is a new development in the law. And so it's just not on a lot of in-house counsel's radar that this could be a potential fallout from actively enforcing a class action waiver. And I think in terms of sort of how these mass arbitrations come about, traditionally speaking, what we would see is an employer is moving to compel arbitration, right? So a class action is filed and they move to compel compel individual arbitration. And so sometimes now, at this point, when you really look to see, is there a real risk of mass arbitration here, and do we need to look at that? The first question is, do we actually want to move to compel, right? And so that's kind of the threshold question. Even if you have an arbitration agreement, do you want to risk a mass arbitration, or do you want to just proceed in court anyhow?
Should the frequency of mass arbitrations be causing employers to make some changes to their arbitration agreements? And if so, what should employers consider changing in the agreements themselves?
So a lot of employers are considering a lot of changes, some of which are untested, and whether or not they are enforceable or could be rendered unconscionable by a court has yet to be determined. Some of the most frequent things that we're seeing, obviously some of you probably are aware of, but just a requirement of an informal dispute resolution procedure. So an individual procedure that requires the employee to engage in a process and making that a precondition to filing an arbitration. We can get into some of the sort of how that impacts on the mass scale and who's determining whether or not those preconditions are met. But that's one kind of easy way to try to turn the tide. One thing that we've been talking a little bit about to clients is delegating to a court whether certain preconditions are met. I mean, of course, normally we would, in an arbitration agreement, everything would be, except the enforceability of the agreement itself, everything would be delegated to the arbitrator to decide. But this idea of preconditions, such as an informal dispute resolution process, could be an area where we'd want a court to weigh in, whether or not that is actually met.
Could you just clarify, what would you be delegating to the court in the agreement?
Whether or not a precondition to arbitration has been met, such as an informal dispute resolution process.
These are preconditions you will have set?
Right, in the agreement itself.
I see, okay.
This is a hotly contested topic, but sort of the splitting of fees and the enforceability and unconscionability principles really come into play here. But traditionally speaking, employers are paying the brunt of the arbitration fees, and to try to shift some of those costs to employees, a lot of that will be prohibited or prevented from certain state laws, depending on what state law applies. But it's something that employers are thinking about to try to curb the costs of the arbitration, the mass arbitrations themselves. And then a couple of other things, implementing mass arbitration procedures into the agreement itself. And we're going to talk a little bit about some of the new rules that have been coming out from various arbitration providers. But this whole idea of mass arbitration is new. And so implementing the idea of mass arbitrations and requiring potentially bellwether trials or something of the sort into the agreement is something that we're talking about with clients. And the last thing that I'll mention is what we would call just an escape provision, but essentially if you have so many that are filed, that there is actually a provision in the agreement itself that allows you to sort of opt out from the mass arbitration and just allow them to pursue class action in court.
Can I comment on this?
Absolutely. And then I've got a couple of comments.
Okay. So just taking them, I think, in the order that Carrie raised them, that is very helpful to me. First of all, the preliminary precondition of ADR. So there may very well be some value in some kind of early ADR or mediation of some sort or exploring resolution. But to do it individual by individual is going to drive up the costs enormously. I would suggest if you find out that there are 500 that are brought by the same people with similar claims, there's nothing wrong with even calling them and saying, let's explore a resolution to this before we start litigating 500 individual claims. So that's just for everybody to think about. On the issue of splitting fees, of shifting more of the cost to the party that the worker who's against whom the arbitration agreement is imposed, I think there's a body of law beginning with Randolph against Greentree in the Supreme Court, which raises the question about whether it's appropriate to impose on the worker a cost way beyond what they would have to pay as a filing fee if they went to court. And so I'm not just, you're nodding your head. I argued that case in the Supreme Court. I'm pretty familiar with it. So I would just suggest that that's something to keep in mind.
If I could just add a
Oh.
comment, I've been writing for 25 years in support of employment arbitration, if properly designed. And I testified before the Dunlop Commission on that. I'm very concerned about some of these ideas. If you have a class action waiver, it seems to me you need to live with it, which means you're preventing a class action. These people will bring arbitrations. And at some point, you might have an agreement. Excuse me, what's your problem?
She's counseling you to talk to
I have this thing as well. I'll talk into the mic for you, Judge. You're requiring arbitration, which I'm in support of, but the main reason I was in support of arbitration is because it provides a hearing for people who will not get a hearing. Joe Sellers is not going to give them a hearing either. He'll bring very important and effective class action, but not for, and that's great, I don't take away from it, but people have retail claims, and arbitration will provide a hearing. So any steps that take away from that seems to me undermines the public policy case for arbitration. So I would urge your clients to think twice about it, because if you start imposing the cost on people for whom you're also denying the jury trial, I mean, you've lost your most, I think, important supporter and others, especially at a time now when everyone is talking about forced arbitration. I think it's a mistake. You have a class action waiver, consider the virtues of it, and one of the problems of the class action waiver is that people like Joe Sellers will bring lots of claims, okay? And maybe over time, there might be some agreement for some sort of non-mutual issue preclusion, which I've written about, but the idea that we're going to have these preconditions, I'm not blaming you. This is not blaming, nor am I blaming,
You're the messenger, we understand that.
I'm not blaming you or your firm with which I was affiliated for at least 3 years, or even the general sentiment behind these proposals. But the idea is you can't have it both ways here. It goes back to what we said in earlier panels. Those people that imposed the no-compete clause on people that were doing, routine factory work, we've now encountered the whole no-compete ban revolution. You act like a pig, in my view, prepare to be slaughtered. I wish we had some reporters here. I mean, in other words, I'm not talking about you or your clients, but you go too far here, the whole thing will unravel. And so I'm concerned about that.
So can I add just
Sure.
one last thing, with
Yep.
respect to what I understand about, at some point, a provision to opt out of the class waiver. If it's one-sided, I question whether courts will allow that to be enforced. If it's a matter, again, of saying, in the event we wish to, we may want to contact the counsel for the 500 who brought their claim and explore some kind of collective resolution. First of all, it's just a matter of contract, so I'm not sure you need to put it in the agreement. You can pick up the phone and say, hey, looks like you got 500 of these, let's find a common way to resolve it. But anyway, just some reactions to what you said.
So let me add another layer of complexity to all this. So the arbitration providers are reacting, of course, to these developments, and AAA has certain procedures and certain rules that address mass arbitrations, and JAMS at the beginning of May set forth its mass arbitration procedures, which are new. And disclosure, caveat, I'm not JAMS. I'm not sitting here as JAMS. I'm a provider at JAMS. But that said, I have some information about the JAMS mass arbitration procedures, and I think they're relevant to the conversation that we're having. So let me just talk for a couple of minutes about that. What is a mass arbitration under the JAMS procedures? It's 75 or more similar demands for arbitration, or some other amount as specified in the parties' agreement, filed against the same party or related parties by individual claimants represented by either the same law firm or law firms acting in coordination. These procedures that JAMS has promulgated are not mandatory. If there is an election in the pre-dispute arbitration agreement, or if the parties post-dispute decide that they want to proceed under the mass arbitration procedures, then they will. But if they haven't, they won't. So it defers to what the parties have chosen to do, either in that pre-dispute or that post-dispute arbitration agreement. Essentially, what will happen is that JAMS will appoint a process administrator. And this process administrator has authority to address a whole range of issues that go to procedural, but they also go to how is this mass arbitration going to proceed? And so the process administrator can deal with questions about whether to batch or consolidate or somehow otherwise group the demands and the claims in the mass arbitration for purposes of discovery, perhaps even for purposes of arbitrator appointment, or even for merits hearing. The rules are more complicated than that. There are a lot of interesting parts to them. They're really, in essence, I think, intended to apply to the earlier stages of the mass arbitration because arbitrator or arbitrators will be appointed who will deal with all the substantive issues that will come up. So the focus is on an efficient way to proceed with mass arbitrations, contrary to what some have experienced before now, or without these kinds of mass arbitration procedures. Also, cost. It'll be less expensive. And I'm going to be really interested to hear what my colleagues over here have to say about that. But it's less expensive to proceed under the mass arbitration procedures than it would be to do it the original way, with a lot of individual actions.
Steve, how do these procedures differ from the AAA?
Right.
Well, for one thing, they're not mandatory.
That's a big
And I'm not an expert on AAA, but my general understanding is that this is by election of the parties, whereas I don't think that's the case.
That's correct.
I think there may also be, and Joe, you may know better than I do with AAA, there may be also a mandatory mediation that's part of the AAA, but correct me if I'm wrong about that. But the point is at JAMS, mediation, it's obviously very highly valued, but it's not mandatory under these procedures. Again, there's deference to what the parties elect to do.
Well, I mean, I do know a little bit more about the AAA using them now. I think they don't have a mandatory mediation, but they give the parties an opportunity to do that. They have much larger filing fees for both the claimants and the employer. I'm not a fan of that, notwithstanding what some people may think about claimants' lawyers thinking we want to drive a lot of costs to the employer. If we can proceed in some fashion with a minimal amount of filing costs, I think that's a good thing. And in that respect, I applaud the JAMS for trying to do this.
And by the way, these don't replace what you may know as the employment, generally rules that are applied to mandatory employment arbitrations, which really do cap the amount that the claimants are going to have to pay in order to proceed. Those minimum standards at JAMS are not replaced by the mass arbitration procedures. Okay.
I was just gonna say, we were sort of having a conversation offline about these procedures, and I think from the defense perspective, the idea that it would be less costly is obviously immediately interesting and intriguing, because this is so costly for employers to litigate mass arbitrations. But the idea of an agreement with claimants or their counsel or counsel working together, the question of whether or not, from our perspective, there would be a disincentive for claimants. I know, Joe, you don't agree with this, but would be a disincentive to agree because of the leverage that is put on, that is there for, to put on employers.
And sometimes in mediation, I do hear from the claimant side, before the mass arbitrations have really been initiated, a warning to the defense side: be careful what you wish for.
Right.
What do you think, Joe?
And let me just say, the fact that I would be confused by this, the fact that I'm not a fan of high costs doesn't mean if they're at issue, I don't try to use it as leverage, because it's available to me. But if you were designing a system that I would favor, I would not impose large costs on either side. I think the employer should bear more costs than the worker for the reasons I've mentioned, but I don't think there ought to be enormous costs at either end. But
You
if
know,
they're,
on the cost issue, does the AAA modify the pre-existing policy that the employer largely pays the filing fees?
so the AAA, as I understand, I'm not a spokesman for the AAA
Yeah,
either.
I just want to know
But
because
I know, my understanding
there were some
is
statements made.
that there are some significant filing fees that the claimants have to pay that are graduated based on the number of claims that are brought together. So certain amount per claimant, up to a certain amount, and then they drop to another number.
So if the claimants opt into the, so you don't know the AAA rules?
I do.
Okay.
I'm not speaking for them,
You're not
a
speaking to the
representative.
AAA, I'm just trying to understand, because
Yeah.
you said,
Yeah,
I mean,
so
I'm concerned that the AAA,
they're much more expensive.
they're much more expensive if you opt into the mass arbitration.
No, in that instance, they're not, there's no opt-in process. If your claims are filed after a certain date when they become effective, which I think was January of this year,
Okay.
then they automatically apply. They don't have the, as I understand it, the opt-in or opt-out process that
I'll
JAMS
have to
has.
talk to my friends at AAA on this one. We're going to have a conference in May 2025 about, I'm surprised at that feature of it. It's automatically imposed on the parties.
It's
If
a
you meet-
rule. It doesn't, I mean,
Well,
I
you can
guess.
have a rule that's not
So I
imposed.
mean, it's possible that the parties could negotiate it, but since it deals with fees that are, filing fees that are paid to AAA, I'm not sure that even if the parties agreed to it, the
Yeah.
AAA would be a party to it.
Right, which means they don't have to administer it. So, okay.
All right, so let's advance into the mass arbitration. It's ongoing. Have you used bellwether hearings in mass arbitrations, and if so, how? Liability, damages? Either of you?
I'll start. Yes is the answer I have. I'm in the middle of doing it now, actually, and I've done it before. Ultimately, part of our goal is to find a point in the process where each side has had enough opportunity to value the defenses and the claims themselves to make meaningful judgments about if there's a common ground in which to resolve it. And often there's some benefit in having some bellwether trials, not an unlimited number, but some discrete number, in which, and I should say at the beginning, as perhaps I said before, we look for claims that have common features. So we're not bringing claims, all of which have different things, because there's no economies associated with us doing that. So if we're looking at a common practice or common policy of some sort that we think we contend is unlawful, and we otherwise have to litigate it 5,000 times, if we can litigate it in 10 of them and see if we get what the results are with 10 different arbitrators, it may give us some guidance on both sides of whether there's likely to be one side or the other that has a better sense of whether there's liability or no liability. And then the damages almost inevitably are individualized because they bear on whatever happened and the like. And certainly, I'll just give one example. I had a case where we started with about 250. It's become many more than that now. And I asked the employer's counsel, who in your company, your client's company, would you want me to depose 250 times? And they said, well, we don't want to do it that way. So we agreed on a global discovery plan, which to me looked a lot like a class action, because we were talking about common discovery and use in a common way and the like. They, of course, didn't agree with me on that characterization. But I think there are benefits to having some kind of negotiated global discovery, so we're using our resources efficiently.
Yeah, and I think I agree with everything you said.
Well,
we're in
I'll have to rethink it.
we're in the same boat. I mean, I do think bellwethers on merits issues. I mean, typically in these types of cases, right, there's some sort of core issue that really needs to be decided that we have different views on, and getting a sense of how arbitrators may come out on that, how they're reacting to our witnesses, is really informative for whether or not there's a path to resolution on a global basis. But from the global discovery perspective, I wouldn't characterize it as a class action type discovery. But from a defense perspective, I mean, typically speaking, the discovery, the burden of discovery and the expense of discovery is falling on the defendant. And so that's another, in terms of resources of the company and obviously monetary resources as well. ESI, I mean, as we know, typically in arbitration, it's supposed to be a limited discovery. It's supposed to be a quick proceeding, right? And so, but when you have these mass arbitrations, there's much more of an argument from claimant side to say, well, but this isn't one arbitration, and so we shouldn't just limit discovery. Discovery has to be much bigger and much broader because we have 200 claimants or 2,000 claimants or 5,000 claimants. This is actually a really big case. And the leverage point is if we don't agree and find some parameters to work within in a global discovery plan, is that you can just go to every single arbitrator and ask what you want. And what we're constantly facing is the argument is that we just have to win this issue once, right? We have to win the issue once if we get to depose the CEO. And then, that cat's out of the bag.
Is there ever an agreement, in your experience, Carrie, that you're going to be bound by these bellwether resolutions? Or they just simply inform your valuation of the case?
Bound on from the
I mean, that you're
individual's-
bound by the arbitration?
Yeah.
That's going to have a multi-claimant
A preclusive
Of a
effect.
preclusive, no, definitely not a preclusive effect.
But it informs your
Yes.
valuation of the
Yeah,
case.
I think we would most certainly have to agree at the outset that it would not have a preclusive
And
effect.
what are the general criteria for deciding which of these cases are appropriate bellwether cases?
So I think from our perspective, we've done it a couple different ways, right? I mean, each side picks a few, or they're randomly selected. I think it's a negotiation about sort of how that we want it to be a fair representation. And I think both sides agree on that. And so typically what I've seen is if we do 5, each side picks 2 claimants and, random arbitrator picks the 5th, or something to that effect. So it's a fair
Good.
representation.
I mean, again, I agree with much of what you said, except I
Sounds like
think
this panel could have been rejiggered.
maybe you should be on this. I do want to speak for a moment about the preclusive effect issue. There's the concept of non-mutual offensive collateral estoppel that applies in courts. And in this instance, because each of the claimants is a separate party, but the employer is the common party, if this were going in court, we would have the benefit of non-mutual offensive collateral estoppel, but arbitration is structured differently. In my experience, the way I use it is not to demand that if we win these, but rather to say to the next arbitrator, is there any reason why this liability issue that keeps
This case
coming
is
up
different, yeah.
is any different, or any different arguments, rather than having to litigate, again, a whole day of hearings, because often you're before a different arbitrator, and it's like Groundhog Day. You start with, let us tell you all about this business that we have already litigated 17 times, and you get a little tired of doing that. And at some point, you say, let us show you some of the decisions, and you can get a sense of whether you are inclined to come out differently, not binding them, but I think there's some economies achieved there.
So, Carrie, should an arbitrator's award in one arbitration be considered by a different arbitrator in another arbitration? Your thoughts?
No.
No. Okay. Something you two don't agree on then.
Correct.
What's the argument against considering it? I mean, it's the same employer,
Yeah.
presumably similar facts.
Right.
Considering it doesn't mean you're
Not bound by
adopting
it, yeah.
Yeah, I just think there's the, at least from my experience, and maybe we just always had bad facts or something. There's just a fear that, right, as soon as that decision is turned over, if it's negative against my client, then there's going to be just sort of a
Spillover.
Yeah, it's a domino effect, and it's really hard to kind of stop that train once it's out of the station.
One other thing to keep in mind is whether the arbitration agreement addresses the confidentiality of the arbitrator's decision, because there are some agreements that will include provisions that actually limit what the arbitrator
Let's see.
can see, exactly.
Yeah, the ones I have had so far don't have that in it, but we still have debates about it. And another issue somewhat relatedly is example that there may be common witnesses that are called in each of these arbitrations because the company produces the same witness to whatever practice that's being challenged. And do you have to call the same witness and cross-examine the same witness? I did this once where I did cross-examine the same witness 9 times. It got a little tiresome. We'd say, Madam Witness, nice to see you. Mr. Sellers, nice to see you again. But at some point, you have to question what you're trying to accomplish by cross-examining the same person, or can you use the testimony from some of the other hearings? It's another question that comes up.
Let me ask a question. Let me go back for a minute to the bellwether proceedings in a mass arbitration. Have you used them, either of you used them with respect to damages, both liability and damages, or have you tended to use them primarily with respect to liability issues?
I've not used them on damages.
So there are 2 sets of issues on damages. One, at least in my experience, one is whatever the law is governing the claim of damages, and the other is what the amount of damages are that are awarded. As to the latter, the amount of damages, certainly everybody's going to be different. At least in most of my cases, there's somebody did something and they're claiming some lost earnings or something like that, and they're going to be different depending on their experience. As to the question of what law governs, sometimes there's a dispute about what law governs some of the particularly damaged claims. Those rulings, I think, could be relevant and shared with other arbitrators. But again, it's, there's a debate about that. But again, having to re-argue the same point over and over again about what law governs is a bit redundant.
I suppose I could see a situation, I've never had it, but where there's, a willfulness component to damages or something of that sort, and you could use a bellwether to adjudicate that issue.
And you're in agreement on, pretty much on how you would select cases for the bellwether?
Yeah.
The two of you are.
Yes, I mean, the purpose of bellwethers, in my view, is to come up with a sample, the outcome from which both sides are satisfied that we've gotten a chance to really value the claims. So there's no advantage, in my view, for one side or the other to load it up with the claims they think are good for them or bad for them, the other side, because they're going to be discredited. So either you do it randomly or you pick a couple and, usually we do them randomly.
Is there any experience with using three arbitrators? I know that's costly. 3 arbitrators in some of these settings. The claimant picks one, the employer another, and they jointly pick a third. I know it's costly.
Yeah, well, and we haven't done that for that reason. It's costly, it's also much more time-consuming because the deliberative process is, a much more elaborate, 3 people having to discuss this. It doesn't mean you couldn't do it, but we haven't done it.
No, we haven't
Thank you.
either.
Yeah, that's an interesting question. We were talking earlier about, are there any changes that employers might want to consider with respect to the arbitration agreements and the pre-dispute arbitration agreements and the issue of mass arbitrations. And I suppose it is an employer's option as to whether it wants to integrate a 3 arbitrator panel process for that. But like you said, more expensive, maybe more cumbersome.
Well, and
Yeah.
Go ahead.
I've had some experience. Sometimes it's very useful
Yeah.
because you have a check on the arbitrators.
right, I mean,
And you'll get a better result on
Some of it-
arbitrary results.
some of it depends on if you, let's say you have 500 of these,
Right.
whether you are going to end up expecting to have 500 different arbitrators, which some employers say everyone has to be a different arbitrator. That's pretty impractical for most, even JAMS and AAA have not an unlimited number of arbitrators. They have, as you know, a process arbitrator who often decides whether they want to aggregate them and still litigate them individually. But if that happens, and let's say they say we're going to appoint 10 arbitrators, then saying let's do a panel of 3 for each of them, for instance, might make more sense. But doing it with 500 arbitrations and then you've got 3 times 500 is overwhelming.
But it's also the notion you don't want to bet the whole company. One reason class arbitration is resisted by employers is like bet your company on the arbitrator choice.
understand.
So you can
Right.
you can curb that risk of arbitrariness.
Right. And actually, I know we're not talking about class arbitration, but having
I know.
class arbitration
Is a different
with
thing.
3 arbitrators
Yeah.
might be something to consider too, as opposed
I
to
agree.
1.
Absolutely.
So we talked about mediation just a little bit earlier. Let's go back to mediation for a few minutes. Are there certain times better than others during this process with a mass arbitration? Are there certain times better than others to take the mass arbitration or prospective mass arbitration to mediation? For example, is it better to wait to find out how these matters are all going to be consolidated so that you have a better understanding of what the procedure is going to be? Is it better to wait until you get some decision or decisions on some of the disputes before you mediate? Is it better to understand really well whether you can come up with exposure analysis and computations that are common to all of them so you can project what it's going to be for the entire group? Or is it best to just kind of follow sometimes the wisdom of the earlier the better when it comes to mediation?
Well, I can start. I think it's not an all or nothing. If you're going to, let's take the example of 500, for instance. There may be some value in having an early mediation before you've litigated any of them, just to see what issues come up and where we're divided, and obviously there'll be a lot of divisions. And then if you want to start litigating them, you come back after trying some of them and then you have a better sense of how to value them. But we're both then informed about what each is thinking about in terms of the strengths of our claims and the strengths of the defenses. And so there may be value in doing an early and then a later.
I agree. I mean, I think from the defense perspective, it's always a little bit dependent on the client and sort of what's driving. I mean, some clients and companies are just dedicated to fighting, and that's just the reality that we live in, and they won't be interested in mediation, and Joe knows
That's
as
fine.
well.
Yep.
And we fight, and they have the leverage that it's very costly, and oftentimes we have the leverage that there's, you know, larger firms on the defense side and smaller firms on the other side, and we're sort of propounding discovery and trying to make life difficult. And so it's litigation, and it's a sort of you're grappling with all of those things. But I do think having a mediation at the outset can be very valuable, even in sort of us educating our clients of kind of the road ahead and the cost ahead, and the potential that a key witness could be deposed 250 times if we don't get the right protocols in place
Right.
on discovery. And so there's just a lot of unknowns. But I certainly think if you agree to the bellwether, the best thing to do after the completion of the bellwether, right, is to then go to mediation and take those learnings and attempt
Yeah.
to see what can be done to resolve the matters.
Carrie, can we go back to the question whether it's in the employer's interest, employer now, to have all this in a pre-dispute agreement? If I see Joe Sellers coming down the road, I want to have an agreement with him. And we can do this, in other words,
You need to
after-
represent me more.
I'm just, I speak truth to power, that's my object. But, you know, then I can see it, but having it in the pre-dispute agreement, it seems to me you're asking for issues.
Sorry,
And
having
I know,
what?
excuse me?
Having what in the pre-dispute?
Whatever the procedures will be on the
Oh.
so-called mass arbitration.
Oh, yeah, I mean, I haven't seen that done yet. It's
Oh,
just
so I must misunderstood
Yeah,
you.
no, it's just something that people are,
They're
clients
talking
are
about it.
talking about,
I see.
sort of heat off the costs and
Right.
associated with this.
Thank you.
So I know that we're sharing our time with the next group that's going to discuss other aspects of arbitration. So I'm conscious of that, but I do want to ask the magic wand question, which is for each of you, if you could wave your magic legal wand, and Sam, you're included in this, if you could each wave your magic legal wand, what would you change about how mass arbitrations are going to be litigated, arbitrated? This was not a planned question.
Yeah.
No, it wasn't. Boy, it's not on my list
This
here.
is impromptu.
I know, it's all right. I have a thought. So first of all, I want to come back to something I said at the very beginning, which is I think we should really sit down with some of us and think through the relative benefits. I realize different companies have different approaches, and they're different. Some are more aggressive and some are more conciliatory. But, you know, in the end, adopting a process that has humongous transactional costs, which is what mass arbitration does. And, you know, if the plaintiffs are successful, lawyers are getting awarded a lot of fees, and the company's paying a lot of costs to its lawyers and to the plaintiffs' lawyers. You know, it's, at some level, looks very appealing, but it doesn't, in my view, serve our clients very well. And so I'm either client, actually. And so I really would urge us to think about, instead of just adopting class waivers just routinely, because that's what everybody does, and I think 65% of the workforce in this country is covered by, as I understand it, class waivers. There may be occasions where it's appropriate, there may be occasions where it's not, but we ought to have a more nuanced approach, and I have some ideas about how to do it, but I don't think it's just a one-size-fits-all, because once you start down that path, you create incentives on both sides. As you say, you can, companies say, so make our day, let's litigate these. We've got a lot of resources and you have fewer resources. But the costs posed on the company are high, the delays for our clients are potentially substantial. There are a lot of ways in which none of us are served very well by this process, in my view, other than the avoidance of a class action, which maybe justifies it all. But I just would invite those who would like to discuss it to have a discussion about some more nuanced approach.
Joe, you said you had some thoughts. What are preliminary thoughts? What are they?
Well, okay, you had to ask. So, I mean.
Put it out there.
Yeah, so one possibility, again, is a mechanism by which the agreement says, you know, there's you're not bound to go through an arbitration until the time when the dispute arises. But in the event the dispute arises and you wish to elect to proceed to court, you have to go through some kind of ADR process, some kind of mediation before you do that, so that there's a real chance to think through, what are you trying to accomplish
A
here?
mediation process before you enter into
To
a
court.
class action waiver?
No, presumably there would be no, under my model, there would be no presumptive class action waiver. The point here would be for an employer to discuss with the employees, how can we resolve this before your lawyers take over this case and start to file some enormous case and litigate a lot of stuff? And build into the agreement some sort of cooling off period, if you will, where there's a chance to sit with a third party and discuss this before the case takes on a life of its own. Just an idea.
We'll talk about it.
Discuss, just to clarify, discuss the sort of the
Employee.
class action type case in
Or-
terms of
well,
global,
the
or
scope of,
the individual's claim?
Either one.
Yeah.
I mean, it could be the individual, and certainly one question would be, do you want to be part of a broader case, or do you want to resolve your claim individually? And that may serve, different people may have different answers to that question. But if their view is, no, I'd like to, I'm challenging this practice that we've talked about and we don't like it, and employer might say, well, before you file this, let's see if we can change the practice. And what can we do to address the harm that you claim you suffered? And maybe there's a way to do this retroactively or to some way that doesn't require a class action or mass arbitration.
Right. Or litigation.
That's what I mean.
Employers should have
Yeah.
dispute resolution systems, internal dispute resolution systems. If that's what you're talking about,
Yeah.
I agree completely with you. I don't know if David Sherwin is here, but, the problem is, you don't get arbitration post-dispute, because of the inherent dynamic.
I know.
If I know, I'm an employer now for a moment, and I know the claimant has Joe Sellers, I'd love to have arbitration, because then I don't have the jury trial and all that, but Joe is not going to give up the leverage of the threat of the jury trial, so we don't get arbitration there. If I think the person is not well represented, does not have a good claim, and David will tell you that over 80% of the charges with the EEOC are actually weak claims, and they're dismissed on merit grounds, I don't want to give him arbitration. He'd love to have arbitration. I don't want to give it to him. Now, so that's the dynamic with post-arbitration. So
I
just to make
understand.
that point. But I do think that part of a good employer and a good dispute resolution system is you work out alternatives. And I think most lawyers actually are not involved in litigation. If they're good, they're representing the claimant, but they're talking to the employer what resolution can happen. For most employees, litigation is the worst thing they can do. They may get some money if they're lucky, but they have tarnished their own reputation. So,
I cut you
Oh,
off
I
here.
mean, I sort of agree with what you're saying, but I think that from a pure mass arbitration perspective, assuming we're kind of there, I do think a mandatory mediation at the outset might be a really good way
take it over, Mark.
to sort of cut to the chase early on before the costs of this, because it can be unwieldy and costly, to say the least, for everyone involved.
on the phrase, by the way, mass arbitration, aren't we talking about mass filings? Because we're not getting arbitration yet. These are
No.
mass filings against a common adversary
It's a filing in an arbitral forum.
in arbitral form, but not arbitrations yet in that sense. Yeah.
Okay.
It's a little bit unclear. Okay. Mark,
Panel, thank you.
thank you.